being able to keep it. So,
in terms of CC&Rs being amended, such as they were when you entered the association and relied upon them, this one I think is, from a statutory drafting and construction perspective, is really troubling. Because what this really means is that if you change the rules after I've moved in, and I perceive those rules as adversely affecting me, well, then they only apply to the next set that's moved in. And then the next set of CC&Rs, amendments, only apply to the crew that move in after that. So every time you amend the CC&Rs, you're going to need this great big chart of who was living here when, whether or not they're going to perceive that as adverse to their interests or not. And in terms of managing such a cumbersome approach, it's almost as if it was designed to be overly cumbersome. The bill is a Christmas tree. It's the kind of legislation that needs to wait until either legislation such as you have proposed is on the books, or the courts have settled these matters. It's interesting, I've heard this morning, or this afternoon rather, Mr. Chairman, that what you've seen are dueling lawyers from opposite sides. We could send them back up Washington to the courthouse, or we could let the local HOA boards decide. But as we've mentioned before, the last thing that the legislature should be doing is making decisions affecting local HOAs. And with that, we'd urge you to...
Another thing that was said is talking about how you can go before a review. If you do something bad, leave the garbage can out past the bewitching hour, you can go for a review. He must be referring to the HOA's kangaroo court that they hold. I mean, they are the cop, the judge, the jury, and the executioner. Doesn't seem fair to me at all. I can't move past that. Okay? And Mr. DeMena talks about changing the rules after he moved in. An example that I'd like to give you of changing the rules, or as he was complaining about the legislators writing legislation. This legislature didn't seem to matter when they took away my homestead exemption protection. I bought my house in 1994. I had the protection of the Homestead Exemption Act. In 1996, those same opposition urged the legislature to pass a statute that took away my protection of the homestead exemption by statute. Nobody seemed to care about that. That was 2 years later.
Virtually every case decided by the Arizona Court of Appeals and the Supreme Court so far has limited the rights of homeowners in homeowners associations and expanded the rights of the homeowners associations. The most recent case, which it goes on and on. There's a number of cases. Underlying all of these cases is, I would assume, a hope by the courts that the legislature will do something. And as attorneys, and as a trial attorney for over 33 years, I got to the point where I felt it was necessary that we come to the legislature with some of these issues. Let me just address one or two things. First of all, my ancestors come from Rhode Island. And those of you who are aware of Rhode Island's history, you'll recognize the fact that Rhode Island is the smallest state. It's also the first state to vote in favor of the Declaration of Independence and to join the Revolution. But it was also the last state to ratify the Constitution. And the reason why it had that problem was because there was a problem with the minority. Rhode Island had a sincere concern about the fact that the larger states and who controlled the majority in the United States would take away the rights of the minority or smaller states. And that's the situation when you have a what Mr. Morgan called a democracy of a homeowners association. We don't live in a democracy, a pure democracy. We live in a republic. We have a representative form of government. You gentlemen are here, ladies and gentlemen are here because you have that, because we have that form of government. Homeowners associations have all the good things, have all the good things about where people live and what they enjoy and doing, and they have all the bad things of having the majority rule in even when the majority is wrong. And what we're hoping to do with this legislation is at least even the balance between the homeowners association and the owners. Homeowners associations are the largest unregulated business in the United States. Morgan. First of all, the wording of this particular statute is not arbitrary. The Arizona courts have adopted a rule of the law called the restatement of the law. It's a scholarly treatise on the law, if you will. And there's a specific restatement called the Restatement of Real Property Third of Servitudes that applies to homeowners associations and other types of organizations. The language from this bill comes from those restatements. That's law that has been talked over, debated, and in fact adopted verbatim by the Arizona courts. So this is not anything that's new or surprising. Secondly, the problem that we see is not with amending the CC&Rs. The question was asked earlier about when someone moves into an HOA, don't they have some notice beforehand that they might have, that there might be a change? Isn't there a process and that they're sort of liable for it? Well, think about this. If you were into a contract and you entered into a contract to purchase an automobile, and the contract said, anytime during the course of this contract, the seller can change the contract at his will, don't you think that would be a significant problem? If the seller all of a sudden decided to say, well, sorry, but we've decided to change your contract and now costs twice as much to purchase the same car. Mr. Morgan referred to what they call the business judgment rule. Well, it's interesting because the courts, the Arizona courts, have now said that the business judgment rule doesn't apply to homeowners associations. They look to the restatement for guidance on the actions of the members of the board of directors. What if I buy aren't I free to go buy someplace else? The answer is no. Presently, for example, if you buy or develop a piece of property in a lot of the municipalities around the valley, Gilbert, for example, you cannot make a subdivision unless you have a homeowners association. It will not be approved. So you really do not have a choice. You have no place to go.
With all due respect, we need a democracy when you live in a homeowner association because you willingly participate under the rules that were established when you moved there. If you didn't read the CC&Rs, you didn't receive them, that's not anyone's fault other than the people didn't get them to you, and that doesn't make the CC&Rs any less what you should be following. And it's a blanket statement trying to solve a lot of societal ills that just I have a problem with. And obviously, it's already been established the courts continue to define the rights of both the HOAs and the homeowners, and whether we like it or not, they tend to be going more towards HOAs.
And what about these ills of society? What has just occurred has been the issue at the heart of the 44-year-old HOA problem. A de facto HOA government under what is essentially an adhesion contract in favor of the HOA is the problem. You've heard that the courts are ruling against homeowners. Why? Because the laws are against the homeowner. The special interests flip-flop between contractual enforcement or granting of liberties to the HOA boards as if they were indeed public government entities. It can't continue in this manner. Who is protecting the homeowner?